Dear students, in this class we are going to look into another very important agreement which is related to the customs valuation, that is the agreement on pre-shipment inspection. Why the pre-shipment inspection agreement is important? And in the SPS class and the TBT class also we have explained that there are so many consignments are rejected from India. Why they are rejected? Because the main concern is with regard to the quality or the SPS measures or TBT measures. In some of the consignments it is found that it is filthy. In some of the consignments there were infection of salmonella, infestation of salmonella, and also in certain cases pesticide residue was excess, in certain cases other problems, mainly the problems are relating to the quality. So, here this particular agreement which talks about pre-shipment inspection. So, the name itself says before shipment there must be an inspection by an accredited agency, so that this pre-shipment inspection will prevent exporting of low quality materials, low quality products, low quality goods, but still there are sizable number of consignments are rejected by the countries. So, this is to be prevented. So, what is this role of pre-shipment inspection agencies? And also what are the obligations of members and Indian provisions on pre-shipment inspection, and what are the Indian agencies also involved in pre-shipment inspection, and we will look into. So, the WTO agreement and the Indian practices we will look into in this particular class. So, pre-shipment inspection, and you can see that this is the final inspection before sending any product abroad, any product to a foreign country, and this is with regard to not only quality, it is not only a quality control mechanism, but also quantity as well. So, the quality professionals before shipments and they will inspect the particular goods. So, the purpose is very clear. So, the products meet the quality standards and specifications which is prescribed by the seller. This is the objective of the pre-shipment inspection agreement, the PSI agreement, but still our number of consignments are rejected. So, it shows our system, whether our system is foolproof or not. So, it is the duty of every country to impose the PSI obligations, pre-shipment inspection obligations, and to come out with administrative mechanisms and also quasi-judicial mechanisms to deal with implement the obligations under the pre-shipment inspection. And at the same time there are this cannot be done by the government. So, because there are so many consignments are going every day exported to other countries. So, the government give accreditation of the pre-shipment agencies for certifying the quality and quantity of the product. So, this certification which shows that the assurances to the importers that the goods conform to the technical specification and quantities which they are prescribed. So, every time, as I told you, that the goods which are exported from India, it is not in accordance with the standard, is not in accordance with the Indian standards, but the standard should be always maybe very high with regard to European Union or the US or any country where we are exporting the products. So, the standard must be in consonance with the requirement of the importer. So, there will be a quality verification, there will be a quantity verification, and most importantly there will be a price verification with regard to the valuation of goods. So, mostly the government deploys the services of private companies. private organizations to do this price check, quantity check, quality check, and they issue a PSI, that is the PSI inspection certificate. So, the pre-shipment agencies, they do this actual checking of this particular goods. And the pre-shipment inspection agreement, which follows the GATT provisions. For example, in the case of national emergencies, national financial interest, and also the compensation and appropriate inadequacies, appropriate administrative infrastructure to be made for the implementation of this PSI agreement. So, why it is required? Why this government should, why it should be a government obligation rather than an exporter obligation? Definitely it is an exporter obligation plus government obligation, mandatory government obligation to do a pre-shipment inspection. So, most importantly, they will look into the quality, the value of goods, and also the quantity and price of the goods. And most importantly, which we can again see, that the substandard goods are not entering another countries, and it's a question of reputation of the exporting country, exporting destination as well as the importing destination. So, it is basically, I would say that it is to maintain the export of quality products to other countries, quality products to other countries. So, here you can see that every agency, these private agencies hired, are looking into the quality of the product and also the quantity of the product, and also to check whether there are any defects, and also to check to ensure whether the production complies with the specifications or in accordance with the contract or the purchase order. So, the specifications, quantity, quality is mentioned in the purchase order. The pre-inspection agencies, pre-shipment inspection agencies, they look into the order, the purchase order, and see that those standards are complied with. So, this is very important with regard to saving the reputation of the exporting country, and also it is very important for the customs valuation. It is very important for the final payment of the importer, and the quality and quantity is to be maintained for all exported goods. So, definitely pre-shipment inspection activities are started with an application, then a verification, yes, verification of quality, quantity, price, then currency exchange rates, what are the financial terms, what is the specification of the goods, and then customs classification. This is to be checked by the pre-inspection agency. So, the HS codes or other codes of other countries, harmonization is already done to see that the sending product is the same which was in accordance with the purchase order. It is the duty of the pre-inspection agency to make sure that it is the same product which is sent to the other country. Then the agreement is negotiated with the agriculture agreement. So, the PSI came in effect on 1995, and mainly to look into the verification of quality, quantity, price. The price includes the exchange rates and then customs classification of goods. What are the obligations of the members under this particular agreement? So, the universal principle of non-discrimination is applicable to pre-shipment inspection as well. So, here the members apply pre-inspection procedures irrespectively of domestic producers and the foreign companies. So, that means you should apply the procedures uniformly to the exporters as well as importers. It is not only to importers, to exporters as well. Non-discrimination. And second is the national treatment. So, one is the MFN clause, other is the national treatment principle. So, the regulations are applicable to exporters and importers uniformly. Then the most important part is the standards, quality, quantity, that is inspections. So, if there is no standards, if the purchase agreement or the purchase order does not mention about the quality, then it should be in accordance. So, that means if the standards are not mentioned, or it may be in the absence, it may be in accordance with the international standards. International standards which we talked about is the Codex standards and other international agency standards. And also you can see that the site of inspection or pre-shipment inspection activities usually happened in the country of export, country of manufacture and country of export. Then what are the other obligations of members? All the informations relating to the product should be given to the pre-shipment agencies. This includes law, regulations and criteria for inspection, price, currency exchange rate, etc., to be given to the pre-shipment inspection agencies. And then also to ensure that these information is made available to the exporters through the pre-shipment inspection points in every country, and the user members to publish these rules and regulations promptly and efficiently, so that the publics and other governments also can access to these particular rules and regulations from everywhere, every 164 member countries of this world. And what are the other obligations of members? Yes, definitely, which includes the protection of business information, which we talked about, the protection of intellectual property. So, whatever the information giving to the PSI agencies, that is to be kept confidential. So, also ensures that provisions are also ensures that the pre-shipment inspection entities maintain procedure for treating and information as confidential. But if the agency did not give confidential information, third party except the governmental entity that made them only to the extent necessary. That means, when you give this particular information to third parties, you have to be very careful. At any cost, the confidential information, trade secrets, intellectual property to be safeguarded, to be protected. So, in certain cases, certain information should not be asked from the exporter. This is with regard to the manufacturing data on patents, unpublished technical data, internal pricing, profit level, terms of contract. This should not be asked. This will be considered as trade secrets or secret informations. So, patent information you should not ask. You should not ask the manufacturing data, and you should not ask unpublished technical data. You should not ask the internal pricing. You should not ask profit levels, and all these should be kept confidential and you need not disclose it to the pre-shipment agencies. So, if there is a conflict of interest, so the PSI agencies to maintain, or they have to disclose the conflict of interest if any. And also at the same time, the pre-shipment inspection agencies should avoid unreasonable delay in inspection of the shipment, because if it is a perishable good or non-perishable good, they should not take unreasonable time. So, the container should not be there in the port for more number of days. So, the inspection report should be ready within 5 working days, and if re-inspection is required, then that can also be done. So, if request is done by the exporter, then the agency or the entity, those who go for verification of price, currency exchange and quality, quantity, inform, give a notice to the exporter in advance that they are going for inspection of these particular goods. And also we said the quality should be checked, the quantity should be checked, the price also should be checked. So, price verification, and this is mainly to prevent under invoicing or over invoicing, which we talked about is the duties, the entire duties are depend upon this particular valuation. And then price comparisons. So, the same country, the price comparisons to be made from the same country during the same course of time, because otherwise the prices may be very high for other the other form of products. It can be similar products, it can be the same products. So, the valuation should be done correctly. Then consignments of value less than minimum value shall not be inspected. That means, in the de minimis level of in the case of de minimis level, and it should not, consignments you should not visit. Transparency. One of the cardinal principle of WTO rules are transparency. So, the pre-shipment inspection entities usually provide to the exporters list of informations which is necessary for the exporters to comply with the inspection requirements. So, it is these agencies to provide sufficient information to the exporters for inspection requirements. So, it means that basically these inspection agencies should educate the exporters about the rules and regulations and formalities of pre-shipment inspection as well as the exporting. So, moreover, the pre-shipment inspection agencies will act as information points where this particular information is available. And also you can see that the members also publish promptly all applicable laws and regulating mechanisms, pre-shipment inspection activities, so that every government, traders, exporters, importers can become acquainted with this such kind of rules and regulations. That means, every member country has to publish all the rules and regulations, all the laws related to pre-shipment inspection, so that it is readily available to the countries. Then protection. We already talked about the confidential information or trade secret. The pre-shipment inspection agency should treat all the informations submitted to them as confidential business information. So, And also third parties, those information given to the third parties also can be considered as business confidential business information. And all these private companies to keep it as a private confidential information as intellectual property. And also no point of time these agencies should diverge in releasing this information, this confidential business information to any entities or not even to third parties, or neither to private parties nor to the government. So, what does it mean? It means very clear that confidential informations, it is the duty of the government to protect the confidential informations. What are the prohibitions? So, the members have certain obligations to do certain prohibitions. So, they should ensure that pre-shipment inspection entities do not request exporters to provide information regarding certain things. We already said that it is manufacturing data, details with regard to licenses or intellectual property or patents, details of undisclosed information or trade secrets, details with regard to process. So, with regard to any information with regard to patents which are pending, then unpublished technical data, all unpublished technical data which may be with the patent office, you cannot ask for. So, the pre-shipment inspection agencies cannot ask for more data than what it is required. Internal pricing, manufacturing cost, you cannot ask. Profit levels, you cannot ask. Then the terms of contracts, and these agencies can request for necessary information only to the extent of the pre-shipment inspection agencies can only ask for inspection only for the purpose of the inspection. And now the members should ensure that there should not be any unreasonable delay of containers in the ports. So, the final documents and completion of inspection, pre-shipment inspection entities, so all these have to be comply with the time frame. So, you can see the other provisions as well. So, either you issue the report now or detailed explanation specifying for non issuance of the certificate. So, 5 days is given to the pre-shipment inspection agencies for inspection. If you are not completing, you have to give a written explanation. So, we talked about price verification. So, the price verification, the members should ensure that the order to in order to prevent over and undervoicing. Overvoicing is also not good, undervoicing is also not good. So, then they should make a price verification, so that it is not going to be undervalued or overvalued. Then the inspection agency shall make its price comparison to be only to the made to find out the export price of identical goods or similar goods. If the transaction value method is not possible, then they should use the identical goods or similar goods from the same country of exportation at the same time, or from the same person if the same person is not manufacturing from a third person. So, this criteria also to be maintained by the parties. Then again, as I told you, the prohibitions, many times we said you cannot ask for the prices shall not be used for price verification. In case of the selling, price in the country of importation of goods produced in such country, the price of goods for export from the country other than the country of exportation, the cost of production, arbitrary or fictitious prices or values. This cannot be asked by the pre-shipment inspection agencies, and there must be appellate review, appeal, revision, dispute settlement procedures. So, a 3-tier mechanism. So, they shall consider the grievance redressal. So, they have to designate officials to consider and decide on grievances. And also you can see that these pre-shipment inspection agencies, if they take arbitrary decisions, and there must be dispute settlement system, administrative machineries as well as quasi judicial authorities to be appointed for dispute resolution mechanism, dispute settlement procedures. And also it is saying that the officers to give a sympathetic consideration for quick decisions. There must be independent review mechanism and procedures. The members should try to resolve their disputes by alternate dispute resolution mechanisms. So, they can use the independent review mechanism as well, and also establish an independent review entity, and to which the exporter and the PSA entities can submit grievances. And compliance to this independent review entity has to be examined the panel of 3 experts. So, exporter representative, then inspection agency, and also independent expert nominated by the independent review entity. So, this review mechanism, review committee can look into if any of the agreements, any of the provisions of these agreements are implemented or not implemented, and a decision to be taken within a period of 8 days. And such decisions of the committee, so the IRE, the independent review entity, is binding on the parties. And here all pre-shipment inspection disputes between countries are done in the WTO. Between they fought the case is fought in the WTO by the member countries, the government, representative governments. So, no private agencies nor the parties can approach the WTO dispute settlement system, only the respective countries can participate as the complainant and the respondents. And every member country has to submit a copy of the laws, regulations and other procedures about the pre-shipment inspection to the WTO committee on pre-shipment inspection. So, you can see that any kind of publications to be notified to the WTO secretariat on PSI. And also you should inform, the committee should inform the members when it will be publicly available. And review to be done at the end of every second year after entering into force of 3 years thereafter. All this time these transition periods are over. Now, no more period is available as transition periods to any WTO member countries, and ministerial conferences from time to time they review this and they come out with solutions. So, in 1996 a working party has been established, had been established at that point of time, and they conduct review, they submitted reports and all approved by the General Council. So, if a committee is do a good job, then this will be accepted by the WTO General Council. The dispute settlement provisions of the WTO DSU is applicable to the agreement on pre-shipment inspection as well. So, the same process, consultation process, then the panel, appellate body, all these provisions are applicable in the case of pre-shipment inspection as well. Then various country practices differ from country to country. As I told, in all the agreements, it is not the objective of WTO to come out with a uniform law among its member countries, but to put a uniform standard. That is the objective of WTO agreement. So, here in some of the practices we will see the Kuwait requires the PSI for regulated products valued at more than 3,000. So, they put certain cap, that is all. Mexico, a variety of goods, they, if it is traded through NAFTA, then it don't require a certificate like shoes, textiles, steel, bicycles. So, variety of goods. Shipment to Saudi Arabia and Kuwait must contain a certificate of conformity for small number of products, very small number of products. And also the key benefits are to facilitate the transparency, promoting transparency in trading activities, and improve the collection of customs duties and taxes. Even this inspection will lead to finding out the dumping and subsidies or subsidized products. And the goods, they make it sure that the goods conform it to the purchase order. The quality of the product is in conformity with the purchase order, and provides authorities with a overseeing power, controlling power through accurate statistics or accurate data. This is to be maintained. If you look into the procedures of pre-shipment inspection, you can see that there is the importer has to lodge a pro forma invoice with the agencies, and it will be passed on to the appropriate officers of the country of export. Then agency conducts physical verification of goods and then ensure that their description matches the information which is given in the pre-shipment inspection order or pro forma invoice purchase order. Then makes final price analysis, then calculates the value. So, the calculating the value with comparable prices. Then the importer opens an import document or license. Then the importer can inform the inspection services in the country of pending shipment, and the terms of each and every condition of inspection is different. Inspection fees are also different. Inspection contracts are also different. So, once the inspection order is forwarded, it should be forwarded to the inspection company office in the country of export. So, you have to give a notice before the inspection is done. And also the inspection company contacts the exporter to arrange date, time, location of inspection. So, all the shipping documents, information, invoices and also documents. So, these submission of documents can avoid even delay. Then no discrepancies are noted during the inspection, and once all final documents are received from the importer and exporter, the clear report of finding is to be issued. So, you should confirm the shipment value, customs classifications, quality, quantity, reputation, all these to be mentioned in the clearing certificates. Then goods are shipped to the importing country, where the importer uses the inspection report to get the imported goods and related customs. So, its goods reach the border. So, without inspection, usually they have to be re-exported to a nearby country for inspection before sending it to the, and then again re-entry, or this is subject to a heavy penalties. Otherwise, you have to file a discrepancy report. Then we will see the Indian provisions. So, India, there is Export Quality Control and Inspection Act 1963 and is amended in 1984, and the provisions of this particular act is applicable for pre-shipment inspection. So, here 1,000 commodities are put in India mandatory pre-shipment inspection, which includes food and agriculture, fisheries products, minerals, organic and inorganic chemicals, rubber products, then refractoriness, ceramic products, pesticides, light engineering, steel products, jute products, coir products, footwear. So, all you can see 1,000 products are put in the Indian mandatory list of export inspection. But still India is one of the country where the largest number of consignments are rejected from the US or it is from European Union. So, what is the, so again you can see the Export Inspection Council of India, which is constituted under this particular act, have a significant role in advising the members and doing these inspections. So, and also we talked about standard of quality. If you are adopting a higher standard, you should inform it to all the members. Then quality, the quality must be very good, otherwise the buyer is going to be in trouble and seller also is going to be in fine. So, and also we can see that, so food safety mechanism which we talked about, so you can see that it can be done during this kind of practices or this kind of time. And certification prices, then certification as of health, certification with regard to authenticity, certification with regard to other exporters under various preferential tariff schemes, laboratory testing services. So, all these are available in India. Then the hazard control mechanisms, the principles of hazard analysis critical control point. So, India issues hazard certificates, quality and safety management systems. So, based on ISO standards are maintained by India and other laboratory testing is done by this council. Then inspection agencies, recognition of inspection agencies is done by and laboratories also. Then, so for rendering you can see that this is all managed by the technically qualified people, manpower. A manpower with a diversified experience in quality control, inspection, notification, and it will be reported back to WTO. And important countries standards and the knowledge about the foreign laws of buyers and specifications are also very important with regard to pre-shipment inspection in India. And especially the BIS mark, the former ISI mark, UG mark. UG mark for all agriculture products are mandatory, and BSI, BSI mark for certain type of goods like electrical goods, it is mandatory. So, but these are not mandatory. ISI certification mark, UG mark are not required to be inspected by the agency, because ISI mark itself is an inspection agency, a certification agency. So, if there is a BIS certification or UG mark, there is no need to check it again. And also you can see that customs authorities must allow such export of such goods even if not accompanied by any pre-shipment inspection certificate, only in the case of BIS certification and UG mark, because it is already passed through the one certification mechanism, right. So, now BSI mechanism, BSI certification and UG mark mechanism. Then again you can see that other international standards, we are adopting standards like ISO 9000. So, it is also the hallmark of a good quality. So, these inspection agencies must ensure that these standards, in certain cases these standards are followed for certain goods. So, the Act is 1963, Export Quality Control Inspection Act. Then Export Inspection Council of India is the Government of India authority to manage and coordinate all these activities, and from India certain products certification is mandatory. For example, meat and meat products, eggs products, poultry products and milk products, fishery products, fish and fishery products. So, there is n number of, almost it was mentioned that almost 1000 products you require a inspection certificate, whether it is Ayurvedic or Siddha or any other product which requires mandatory list requires a Export Inspection Council of India report or the private agencies reports. So, I would say that these private agencies, India also hired only private agencies, a series of private agencies, international agencies are hired to issue these particular certificates. So, if I want to export certain things, they will go to these particular agencies and get this certificate certified, and then they send it with the certificates. So, the shipments, especially with regard to quality and quantity, is very important, because these, if they stop, the pre-shipment inspection agencies stop working, then we will be exporting bad qualities. There will be more and more number of export rejections will happen. And also the GATT principles. The GATT principles are followed by the pre-shipment inspection agreement. So, because there is a lot of finance is involved in export and import, and this the pre-shipment inspection mechanism is one of the finest systems all over the world to send only quality products, to check the quantity and also check the prices. So, and every country has administrative mechanism and quasi judicial mechanism for review of the agencies, pre-shipment inspection agencies, the certification program. It is the duty of every country to make inquiry points, so that all the rules and regulations will be circulated to the WTO member countries. Transparency. Transparency is also very important factor in pre-shipment inspection, and certain goods pre-shipment is mandatory, and if you already have a BIS certification or AGMA certification, then there is not mandatory, but the government should, India should focus more on exporting only quality products, because it is a question of Indian reputation, reputation of the Indian products in the international market. So, the inspection agencies to be strengthened, or the inspection agencies to be their working should be facilitated, so that we can send more and more goods which will contribute to the economy. So, we talked about in this particular agreement the basic purposes, basic provisions of the pre-shipment inspection at within the WTO agreement as well as the domestic authorities. What are the laws and regulations for domestic authorities to look into this particular agreement? So, this is all about the pre-shipment inspection. Thank you.